Welcome to UC News, ucnewscanada.ca. The Canadian Crisis Response, I'm Dr. Dave. The Mayor and Council have issued an urgent plea for help from Quinte children. Decades have passed, and the entire team combined cannot attain the grade school standards of math, language, reasoning, and logic needed to write basic policy. In dog licensing, this is describing dogs, dog problems, and solutions. The Supreme Court of Canada has ruled that this task is not particularly onerous and can be accomplished by any average reasonable person. The standard they set is further at the lowest level of explanation, preponderance of the evidence, describing the problem and a reasonable solution based on what seems most likely. When the Mayor and Council remove the right of citizens to decide, which is an illegal removal of rights, rejecting equality under the law, it is their responsibility to provide reason. The concern here is that the entire team combined lacks the basic cognitive capacity to complete this task at a grade school level, and further remain trapped in a juvenile stage of moral reasoning, unable to complete their work based on the inherent principles of justice learned naturally in families. When children want a dog, the discussion with parents naturally revolves around accepting responsibility, with the benefits and disadvantages discussed reasonably based on the facts about dogs. Want is distinguished from need, cost is discussed, and in this process appeals to fairness arise so early in childhood development that it is likely this concept of justice is embedded within human biology as a sense of equitable access to the resources required for survival. Further, there is the inherent context of care, particularly focused on the needs of others with emphasis on personal development. With such freedom of choice comes significant responsibility in the bearing of ongoing workloads. All of the lessons learned in this exercise are embedded within the principles and practices of justice within the Supreme Court system, such that there is little difference between a citizen's sense of justice and the Supreme Court processes the Mayor and Council must obey. These are your Section 1 rights to reason. There must be an explanation, it must be understandable, and it must have sufficient detail allowing engagement and discussion or change if needed. It must have a clear purpose, with a clear and demonstrable effect, a task easily achieved by the vast majority of grade school students. Under Section 3 of our Charter, elected officials have no particular qualifications, giving them special powers over anyone else, as anyone can describe dog problems and potential social solutions tied to a reasonable and fair economics. This is equality under the law, recognizing that we have employed our civil servants to do the work we paid them to do. The Mayor and Council have refused to do the work. They claim authority, but authority under Section 1 of our Charter is the demonstration of competence based on fact, evidence, and reason, directly coupled to application of the principles of justice that arise naturally in families. This is the fact-based balance of considerations used naturally by fair and honest citizens doing good work. Everyone in society can explain what they are doing and why, the obvious exception being those with mental health issues or engaged in criminal activities of fraud, deception, force, and theft. Authority is based on knowing what you are doing, with mental health being based on consideration of the impact of your actions on others as the basis of law. Section 1 of our Charter is a test of cognitive capacity required to do the job with a sense of justice that does not abuse the lives and rights of others. Such persons cannot control themselves around people and money, aiming to break the law and get around it, and will say and do anything to get money. Refusal to work, refusal to represent, demands for money without reason or cause, threats if we do not comply. Well, show the law we are required to obey. The mayor and council deny access to the law, saying it's secret. They refuse to answer questions, refuse to recognize City Hall as a judicial body required to obey the law, refuse to do the job we elected, hired, and paid them to do. They block and obstruct, goad and taunt citizens, spending millions on obstruction of justice, saying that if we want justice, get a lawyer. Defining our guilt as a refusal to obey their every whim, which has no basis in law and under Section 52 of our Charter cannot be regarded as law. They get very angry if we dare ask questions, and have put in place a fee per question with no guarantee of a valid or truthful response, even though they are bound by the law to tell the truth, the whole truth, and nothing but the truth. These are crooks, thieves, and liars, and the criminal code charges are fraud, sedition, theft, and organized crime. We can describe such behavior as the mental state of a 5-year-old screaming and demanding money, but incapable of presenting any reason whatsoever. Nowhere in Canadian society are such behaviors acceptable, for Canadians are bound to obey Canada's top laws of care, justice, and reason, required by law to regard these issues of mental illness as inherent unfitness for duty, with the degree of seriousness required under Section 1 of our Charter and under the Ontario Mental Health Act. City Hall is further no place for those who break multiple sections of the Canadian Criminal Code, aiming to reject our justice system and replace our democratic form of government with the working mechanisms of an authoritarian state. What business demands money by force and refuses to say what service is provided, if any, or why it costs so much? Neither is this legitimate government, for all workers in government are obliged by duty and responsibility to obey the law. Instead, the mayor defines the law as obeying him, demanding money without reason and no evidence of work done. The mayor and council then fly into a rage if we dare ask questions. They refuse to answer and launch an all-out attack on the basis of law and legal democratic government, whining and crying like the babies they are about how the people won't obey their orders and give in to the destruction of our lives, our country, and the removal of essential rights and freedoms to decide how we want to live based on reason and care for our lives and the future of our children. Claiming such rights of decision-making denied to others, and yet not demonstrating the competency required to do the job, and further denying our equality under the law to do the job this pathetic team refuses to do, even though obligated by clear and specific responsibilities to obey the law and do this work. We understand the mayor and council want to run a dictatorship, but Canadians are free to choose. Obey the mayor, who does not obey the law, or obey the Supreme Court of Canada plan for our lives. In this plan, children have considerable say about their lives and future, with parents representing them as legal guardians deeply concerned by any and all policies affecting their well-being. Children can most certainly understand and write up ideas of dogs, problems, and solutions, and are required to do so in reports. Teachers and parents then assess the work, present the workable policy for consideration under due process, and if necessary, have that work assessed by a judge. We know this as a legal and healthy structure for an engaged democracy in which each person can exercise their substantial rights and freedoms of competent, caring decision-making, and the responsibility of every citizen to do their best and uphold the law. For to do otherwise is to exhibit the deepest violation of conscience and duty to ourselves and humanity. Such is the law we are required to obey in an engaged, caring democracy, putting its best ideas forward for debate and practical application, respective of the lives, rights, and freedoms of all.